Yes, my lordship. My ladyship, I beg to mention item number 21. My lady,
1 minute. Yes.
item 21. My lady, led by senior Dr. P. Todi. He's not keeping well. He has to undergo a knee surgery, it seems. I was informed that. So, if your lady may be kind enough to grant us 4 weeks, my lady. Lordship. I've taken the consent of the EPP also.
Learned counsel for the petitioner, Mr. Fosiko Forte, submits that the leading counsel is indisposed and accordingly he prays for listing the matter after 4 weeks. Stop. Learned counsel, Mr.
And Moses, for respondent number 7.
Respondent number 7.
My name may be reflected, Lordship.
And the public prosecutor have no objections. Stop. List after 4 weeks. Stop. The name of Mr. N. Mose may be reflected in the cause list as counsel for respondent number
7.
Lordship.
My lady, this is interim. Can the interim continue?
The interim order passed earlier shall continue till the next date. Okay.
Can you oblige?
Oblige.
May I speak,
Yes.
Your Ladyship? Your Ladyship, I beg to mention item number 15. 1-5. Your Ladyship, here I have the instruction to appear for item respondent number 4 and 5.
Which item? Which item?
15.
15.
Yes.
Yes. Respondent number
4 and 5.
4 and 5.
Yes.
So you need some time.
Can they allow me some time? Yes.
Learned counsel for the petitioner, Ms. Such and such present. Stop. Learned counsel, Mr. James Newmai, submits that he has received instructions to appear on behalf of respondent number 4 and 5 and accordingly prays for 3 weeks time to receive instructions
Lordship.
and to file his Vaklanam.
There's an
List
interim.
after 3 weeks. Yes.
There's an interim in this.
List after 3 weeks is prayed for. Stop. The interim order passed earlier shall continue till the next date of listing. Yes.
Okay.
Yes, Lordship.
Yes.
Lordship, I beg to mention item 18.
18.
Yes, Lordship. Lordship, we have instructions to appear on behalf of respondent number 1.
1.
Yes, Lordship.
Okay.
Can you allow 4 weeks time to fill our bakalat number as well as our affidavit in reply?
Learned counsel for the petitioner, for the appellant, Mr. Such and such present. Mr. Such and such learned counsel submits that he has received instructions to appear on behalf of respondent number 1. Respondent number 1 is the insurance company.
No, Apex Manpower Service. The Apex
The Apex Manpower Service.
Yes.
For respondent number 1, and prays for 4 weeks time to receive instructions and to file his power. So, prayer is allowed, list after 4 weeks. Yes.
Also blessed.
Yes.
Bless your Lordship. Ladyship, I would like to mention item 15. I am for the state
15.
respondent,
15.
Lordship. I am for the state respondent number 1 to.
Item 15, I think it's already mentioned.
Oh,
Item 15 is
Sorry.
civil revision, isn't it?
Please, my
Who's
lady.
appearing, PP? You have served notice.
Yes,
Served.
my lady.
Noted counsel, Mr. Such and such present for the petitioner, Mr. P.J. Momi accepts notice on behalf of the state respondents. When can you obtain case diary?
Next week.
20th, 20.
No.
List on 27, on which date the learned PP shall obtain the updated scanned copy of the case diary.
Bless you.
Please, my lady.
Yes.
Uh, my lady, this is an appeal along with the accompanying alia for the stay of the judgment and award, my lady. My lady, this appeal has been filed against the judgment and award dated 23/3/2026, passed by Learned MSCT Dimapur uh, for the compensation amounting to rupees 85,96,000. Uh, the sole ground was in the main case that the accident was admittedly head-on collision. However, denying all the aspects, the learned tribunal has fastened the liability upon the appellant and directed the appellant to assail the uh,
Okay.
compensation.
The instant appeal under section 173 of the LV Act has been preferred against the judgment and award dated 23/3/2026, passed by the learned MACT Dimapur, Nagaland, in MAC case number 11 of 2025. So, Para heard learned counsel Mr. V. Debnath for the
dated 4/02/2026.
Okay, who's appearing? You get the CD, okay? The instant application under section 497 of the BNSS read with section 438 and 528 of the BNSS has been filed by the petitioner praying for release of the seized vehicle Xylo diamond white bearing registration number, chassis number and engine number you just see from the cost title, okay? Which has been seized in connection with special case number 9/2025 arising out of narcotic PS case number 5/2025 under section 21C/60 NTPS read with section 61 of the BNSS. Stop. Para. Learned PP, Mr. V. Jamomi, heard learned counsel for the petitioner, Ms. such and such, and also Mr. V. Jamomi for the state respondents. So list on. It's from Kohima only. Next week. List on 21/7, on which date the learned PP shall produce the updated copy of this case diary.
Please, Your Lordship. Your Lordship, here the present contempt petition is for non-compliance of this Honourable Court by judgment and order date CAV dated 12/2/2026.
Where is the judgment page?
Your Lordship, the judgment is in Annexure 1, page 8. However, the relevant portion is in page number 17, para 24.
The instant application under section 11 and 12 of the Contempt of Courts Act read with the Contempt of Courts Gauhati High Court Rules 1977 and Article 215 of the Constitution of India has been preferred by the petitioner alleging willful non-compliance of the order dated of the judgment and order dated 12/2/2026 passed in WPC 313/2024. Stop. Learned counsel, heard learned counsel for the petitioner, Ms. Such and such. Stop. Learned counsel submits that by the said judgment and order dated 12/2/2026 in WPC 313 of 2024, the state respondents,
It should be 2024.
oh yes, 313 of 2024, the state respondents have been directed to grant notional regularization of the service of the petitioner for the purpose of extending pensionary and retirement benefits as she had retired from service on 31/1/2025. Stop. It was also directed that the exercise shall be carried out by the respondents number 4, 5, 6 and 7 within a period of 3 months from the date of the order. Stop. It is also submitted that a copy of the said judgment and order had been served on the respondents by letter dated 13/2/2026, which was received on the same day.
Yes,
Which
madam.
was received on the same day by the respondents. Stop. Para. Issue notice returnable in 4 weeks. So the learned counsel for the petitioner shall take steps for service on the respondents by speed post as well as usual process within a period of 3 working days from today. List after 4 weeks.
Acknowledgement.
May I please, my lady? My lady, this is an application under section 11 and 12 of the Contempt of Courts Act 1971, read with the Contempt of Court Gauhati High
What
Court
was the
Rules 1977.
direction? What was the direction?
Direction is at page 8, annexure 1. relevant portion is at para 20. Para 20 is at page 17.
Yes.
My lady, if I may be allowed to read. Having interfered with the said notifications dated 17 to 25, this court directs respondents to resolve the issue of the post to be held by the petitioner in the commission while continuing therein with the status of deputy secretary. More particularly, in terms of the speculations contained in the notification dated 9/8/2029, the respondent authorities would now arrive at a decision as to whether the petitioner would be required to be continued as the deputy secretary of the commission, and if yes, the post against which he would be posted against. The respondents shall also arrive at a decision either to upgrade the post of Under-Secretary of the Commission to that of Deputy Secretary, or downgrade the post of Secretary to that of Deputy Secretary for the purpose of continuance of the petitioner as the Deputy Secretary of the Commission. This is the direction. Lordship, at page 18, para 22, the same exercise would now be undertaken and concluded by the respondents' authorities with passing of final orders determining the manner in which the petitioner herein shall hold the post of Deputy Secretary of the Commission within the period of 3 months from the date of receipt of this certified copy of this order. Order was passed on 24/11/2025, and in that respect, the petitioner has served a notice to the 3 respondents on 2/6/2026, which has been received, which is at page 20. Annexure 3.
The main respondent would be PNAR, actually.
PNR, yes.
But this is received by Chief Secretary's office.
Chief Secretary, there's at the bottom, it's
Where is the PNAR? Okay.
PNR. Seal is not clear, but the anything is clear. PNR.
The instant application under section 11 and 12 of the Contempt of Courts Act, read with the Contempt of Courts Gauhati High Court rules, and Article 215 the Constitution of India, has been preferred by the petitioner, alleging willful non-compliance of the directions made by this court by order dated 24/11/2025 in WPC 45 of 2025. Stop. Learned Counsel for the petitioner, Mr. Fosika Pote. Stop. Learned Counsel submits that by the order dated 24/11/2025, the respondents had been directed to comply with the order of this court within a period of 3 months from the date of receipt of a certified copy of the order. So, Learned Counsel also submits that the copy of the order has been served on the respondents by letter dated 2/6/2026, which has been received by the respondents on the same date. Hence, the present petition. Issue notice returnable in 4 weeks. So, the Learned Counsel for the petitioner shall take steps for service on the respondents 1, 2, and 3 by speed post as well as usual process within 3 working days from today, least after 4 weeks.
Lordship, it can be 3 weeks, Lordship, since all the responses are from Kohima only.
Okay, 3 weeks. Issue notice returnable in 3 weeks.
I'll oblige, ma'am.
Item number 6.
Millets in item number 6, 7, and 8 minutes. I appear on behalf of the petitioner.
Yes, these are analogous matters. Is it connected?
I'm sorry. Connected matters, Millets. Item 6 and 7 are against enforcement directorate, Millets. Item 8, I filed the petition seeking quashing of the FIR in the scheduled offense, whereas ED has moved an application for impleadment.
ED has moved?
An application for impleadment in item number 8.
Okay. So what do you want now?
Millets, in item number 6, if your ladyship may please have writ petition 26. Millets, on 30th April, they filed an additional affidavit. Millets, that additional affidavit is also annexed with a supplementary prosecution complaint running into all 20,000 pages, Millets. So, Millets, I take some time to go through that complete annexure, Millets. It's running into 20,000 pages, your ladyship. So, Millet, some considerable time is required.
The IA contains 20,000 pages.
Yes, Millet, the additional affidavit that they have filed.
Additional affidavit.
Yeah. And Millet, in item 7, if the learned counsel for ED agrees to my submission, this can be Millet disposed of. Millet, in item 33, I challenged an order dated 16 September 25, where the ED moved an application under section 19 of the PMLA seeking permission of the learned trial court to arrest me. Now, subsequently, Millet, I have appeared. My bail bonds have also been accepted. So this can be rendered infructuous, Millet, and can be disposed of if the learned counsel for ED agrees to my submission.
Item 7.
Item 7, Millet.
Item 7, infructuous. Where is ED counsel? Who's appearing for the ED?
I'm appearing
Okay,
on behalf
yes.
of
So their submission is that now 7 has become infructuous. Criminal petition 33.
I have been admitted to regular bail before the trial court.
The bail bonds have already been executed.
They can seek instructions, Millet, in that case.
If you want to seek instructions, it's okay. Otherwise,
seek
we'll
instructions.
dispose it.
I'll seek
You
instructions.
want to seek instructions?
Yes, sir.
Okay. So when do you want?
Millet, 4 weeks.
After 4 weeks.
Please, Millet.
Okay. Learned counsel, Mr.
Hemant Shah, Millet.
Shah, appearing for the petitioner in WP, in this WP, first pass the order in item 6. For the petitioner, submits that the Enforcement Directorate has filed an additional affidavit. Additional affidavit is filed in WP Criminal 26, isn't it?
26 of 24.
That the Enforcement Directorate has filed an additional affidavit which runs into more than 20,000 pages, and accordingly he requires some more time to go through the same and file a rejoinder if so required, if so advised. Stop. Learned counsel therefore prays that he may be given 4 weeks time for the same. Stop. Learned counsel, Mr. M. Solo, appearing for the
petition.
for the
Number
peti-
one.
Oh, India.
Assisting.
Oh, assisting. Okay, okay. Then Mr. K. Angami, learned public prosecutor, appearing.
Yes, Your Lordship. Only in item 8.
Oh, okay. Then in 6.
6 and 7 is for the, yes.
It's AD only.
Yes,
Okay.
6 and 7 only ED.
Learned counsel, Ms. Such and Such, appearing for the Enforcement Directorate on behalf of YP Gupta. On behalf of
Keduvi
YP.
Joso. Keduvi.
Oh, okay. On behalf of Keduvi Zotso has no objections regarding the prayer. Stop. Accordingly, list the matter after 4 weeks. Give a date. Today is 13th, so 20, August 10th. August 10th.
Please, very well, Millet.
List on 10th August, okay, for admission hearing. Then in item 7, you write, learned counsel for the petitioner, Mr. Singh, submits that this matter has become infructuous as the petitioner has now been granted regular bail and the bail bonds have already been executed. Stop. At this submission, Ms. Such and Such, appearing on behalf of the Enforcement Directorate, has sought for some time to receive instructions regarding the same. Stop. Then what about 7 and 8?
Millet, 7, we have just made a submission that the bail bonds are executed.
7 is that one. Then in 8,
Millet, in 8, we are seeking quashing of the FIR, which is the schedule offense in the ED matter. Millet, State of Nagaland is a party and Enforcement Directorate has moved an application which is IA Criminal 4 of 2026 for their impleadment.
so can this be separated or can it has to be,
Millet, all arising out of the same nutshell. So, Millet, in my humble submission, this may all come together.
okay, it will come together then. Item 8 also, in view of the order passed in WP Criminal 26 of 2024, list the same along with such and such on 10th August. Okay. Yes. Any interim orders?
No, Millet.
Okay.
I'm so grateful, Millet.
Obligation.
My lords, I'm deeply sorry. I apologize. I was not able to mention in the mentioning hours. My lord, can you accommodate for one urgent matter?
Unlisted?
Yes,
Unlisted motion.
yes, ma'am.
You've already filed it.
I have filed it this morning, and I was late. I was stuck in the registry.
What is it? What matter?
This is for implement. The matter is listed today in item 12. This is a contempt petition 16 of
16 of 25.
yes 2025. Anytime the government will take the advertisements or steps, it will affect my rights. So I'm requesting
Okay.
this.
If it's ready,
Yes.
you give the nation name.
Diplomas.
If it's not rejected, this one.
Prohibition item number 9.
Some instructions you are supposed to. With regard to communication such and such from the Undersecretary.
Yes, sir. Brother.
Can't read.
Lordship.
An attempt was made to dispose before the vacations, but the instructions came only after the vacation. So
Now by this order, minor penalty has been imposed on the petition.
Disciplinary proceedings over and penalty of censure has been imposed.
yes, my lord. And the a letter has been written, which I have annexed at annexure 14, page 105. The type copy is at page 106. The BNR department has written to the Deputy Commissioner Peren. To rescind the earlier communication for initiating criminal proceeding against the present petitioner.
In view of the disciplinary proceedings.
Yes. So nothing remains.
So nothing remains now.
Yes,
Lordship.
yes.
This is written to Deputy Commissioner.
Lordship. Correct.
So after that, has the Deputy Commissioner taken steps regarding the criminal
No,
case?
no, my lord.
No, no. The FIR is at annexure 12, page 97.
Okay, thank you.
Yes. This FIR was also written
FIR page
97,
97.
based on a Lukayukta report. Lukayukta gave the discretion to the government. No specific mandatory direction was given.
But actually, on the basis of the PNR letter, the Deputy Commissioner should have written something to the OC, isn't it?
Yes, my lord.
Then only it can be finally disposed of.
But nothing as such has been written.
Because unless something is there, they will continue with the investigation.
Yes, yes, yes.
Unless something in written
Yes.
is there.
Yes. So, which is why we are here before this honorable court praying for quashing of the criminal proceedings. Otherwise, if that letter has been written,
During the pendency of this petition, this order was passed, isn't
yes,
it?
yes, it was passed only recently on 10th
Just
of July.
recently, 10th of July.
The instant petition under section 528 of the BNSS has been preferred by the petitioner, praying for quashing of the FIR dated 23/1/2026 lodged against the petition. Stop. Para. Heard learned counsel for the petitioner, Mr. Santiago, as well as Mr. V. Jimomi, learned public prosecutor for the state of Nagaland. Stop. Para. By filing the instant petition under section 528 of the BNSS, the petitioner has stated that 97, huh?
Yes. Prior said text
that
22 Mano.
an FIR had been lodged by the Additional Deputy Commissioner Jaluki, Nagaland, dated 23/1/2026 against the petitioner. Stop. During the pendency of the said investigation, comma, the government of Nagaland in the Department of PNAR had written to the Deputy Commissioner Perin, Nagaland, by letter dated 3rd March 2026, stating that the competent authority had decided to rescind the earlier communication for initiating criminal proceedings against Sri C. Wangan WANGAN NCS in view of the disciplinary proceedings which are already underway. Stop. Para. The learned public prosecutor at this juncture has produced a copy of the order number PAR-4/23/2020 under bracket NCS close bracket dated 10th July 2026 by which the Department of PNAR has imposed the penalty of censure in inverted commas CANSUR of censure upon the petitioner herein, thereby bringing the disciplinary proceedings to a conclusion. Stop. Para. In view of the above mentioned developments, comma, the learned counsel for the petitioner praised that the FIR dated 23/1/2026 in connection with Chaluki PS case number 3/2026 under section 7 small b, 13(2) PC Act read with section 61(2)b, 3182 and 3363 of the BNS and all the consequential criminal investigation/proceedings pending against the petitioner may be quashed and set aside. Which one is this impugned order dated 10/4?
Here, we applied for discharge before the sessions court.
Okay,
at Perian, but
which was dismissed,
yes.
including the impugned order dated 10/4/2026 passed by the learned district and session judge Perin, Nagaland in the aforementioned case. Stop. Learned counsel for the petitioner therefore submits that as the government of Nagaland had already decided to withdraw the criminal proceedings against the petitioner, not withdraw, but what is that?
Resent.
To rescind the criminal proceedings against the petitioner in view of the disciplinary proceedings which were underway, nothing remains for investigation as the disciplinary proceedings have already been completed by imposing the penalty of censure upon the petitioner. Stop. Para. Learned public prosecutor, what is your submission?
Lordship, basing on this order, Lordship.
Learned public prosecutor also fairly submits that in view of the decision of the government and in view of the order dated 10th July 2026 by which the petitioner has been imposed the penalty of censure, the matter is left to the discretion of the court. Stop. Para. I have considered the submissions made by the learned counsel for the parties and also perused the pleadings. So, it is observed that the FIR dated
23/1/2026.
23/1/2026 was lodged against the present petitioner by the Deputy Commissioner Jaluki Nagaland,
Additional.
Additional Deputy Commissioner Jaluki Nagaland, on the basis of a what is that, a recommendation, or what was it?
Lokayukta,
On the basis of a, was it a recommendation or?
yes, at page 32, annexure 5. The relevant portion,
32.
yes. Relevant
No,
portion
but-
is at type copy is at page 78. The order is dated 30/10/2024.
On the basis of a recommendation, recommendation dated 13/11.
30/10/2024.
Okay, dated 30/10/2024 by the Nagaland Lok Ayukta,
Passed in
passed in
Lokayukta case number. I have given you my synopsis, the second line, instead of
1 minute.
flipping through multiple pages.
Passed in case number A dot capital A dot NLP dash 01/2023. Is it?
Yes.
Yes. Stop. In spite of the said communication and approval of the government to rescind the criminal proceedings against the petitioner, the Deputy Commissioner Perrin did not take any steps. Moreover, the petitioner had also moved an application. This was after this letter was written, after the 3rd March letter was
Yes,
written.
yes.
Had also moved an application before the District and Session Judge Perrin for discharge, vide IA 9/2026. However, the said application was dismissed by impugned order dated 10/4/20.
Clear yourself. She's a little far from the microphone.
In view of the ensuing developments after the registration of the FIR dated 3rd March 2026, this court is of the view that it would be a futile exercise to proceed with the criminal proceedings, as the same would not result in a conviction. Stop. Accordingly, the impugned FIR dated
23/1/2026.
23/1/2026, as well as the impugned order dated 10
10/4/2026.
10/4/2026, passed in IA 9/2026, is quashed and set aside. Petition stands disposed. Yes.
Deeply obliged.
Yes.
Yes.
received the affidavit in opposition this morning. So if is the affidavit come, my lady?
Actually, it's better if we dispose of the entire FA instead of going for the interim order.
Yes.
Okay.
Okay.
What are you saying in the objection?
May I please, Your Lordship? We have received an order vacating the interim order which was passed on 6/4/26 by IA 140/26. So we have already submitted our reply, affidavit of opposition for that, and the copy of which was sent to her on Saturday, and the hard copy was handed over to her today. So we would like to raise objection on this for dismissal of the said petition. Why? Because in the IA, a lot of misnomers has been mentioned by the opposite party.
No,
Lordship,
but the orders, they have enclosed the orders of the court by which it shows that it was not disposed.
no, Lordship, I
And
will
even
come
trial
back
had not started.
I will come back to that.
Then
Lordship,
how could you have made the statement that it was for final argument?
Lordship, I'll
It was
clarify.
never for final argument.
No, I'll clarify to your Lordship. Lordship, this appeal is arising from this custody case of the Mabur 123. It is a very long-standing case. Lordship, since the case was very long-standing and there was no progress, the parties decided that we shall go for final hearing. So accordingly, the two parties, they had a discussion and they informed the court that this case may be disposed of. So 1123 case was heard on 30th March. After hearing the case, the court stated that the custody of the children will go to the mother on 30th order.
The order was passed in the IA.
Okay.
The IA, not in the main appeal. It was passed in the IA.
So in the IA, it was passed on 30th March that the custody of the children will go to the mother. So we came up for this appeal in our IA. So our IA was registered as first appeal, FA 126. And along with the IA, first appeal, we filed interlocutory application number, registered number as 52/26. And from this 52/26, we got an order, stay order
No,
of...
see, Mr. Lota, these petitions, such petitions should not be kept pending for a long time.
Lordship, that is why...
it concerns the custody of the children. So we will dispose of the FA today. Okay. We'll hear you on the FA.
Lordship, so
Yes.
I'm going to submit on the FA.
First, you submit on the maintainability.
Lordship,
Yes.
I expect to submit before this honorable court that the respondent had filed this on the ground that we have misled the court.
Yes.
That is point number one. Now, as regard to misleading the court, it was the consent of both the parties to have a final disposal of the case, so they approached the court in the lower court. So the court dismissed that IA giving the child to the mother.
No,
That
but
is
how
on
can the
30th.
case be finally disposed of without adducing any evidence, without any issues?
That is now, since the main case is not handled by me, I have just come for first appeal of this IA only, where order was passed on 30th March. So against that order, I have come up, we have filed first appeal, and first appeal 1 of 26, then on 30th, again, along with the first appeal, I came with this IA 52 of 26, and with that, on 30th order was set aside, because they had given the child to the mother. And we are not aware that the case is pending for such a long time because it is handled by some other advocates. So, in that original case, the court had fixed 16th of April. After disposing this IA petition, 16 was fixed. On 16, the court didn't appear. So on 17, it was postponed to 17. On 17, the court appeared. Both the parties appeared there. When the court started, the mother came and said, this is his child, let the child go to the father. Because I have to go for my treatment. So that is the fact of the case. Now on 17, if we see, although the mother has stated that the child be given to the father, the court didn't record that. And instead of recording that, if we see this 17 order, which may be seen at the page Annex 30 of our present petition.
No,
Page
Mr.
16.
Mr. Payas, let's do something. We will just hear you on the FA. Okay, because
No, the thing is,
ultimately-
I'm submitting on FA.
FA, okay,
Yes.
okay.
So
Page
page 16,
16, 1-6.
1-6, Annex T. Annex T, dated 17/4/26.
Page?
Page 16, Annex T.
Page 16 is a different thing altogether.
My lady, I think he is referring to the objection, copy of the objection that he has filed.
Yeah,
I'm looking at the FA.
no, objection.
No, objection in the IA.
Yes.
No, you forget about the IA. You just keep the IA aside and you submit on the FA.
Okay,
main
fine.
FA.
Okay, in that case,
FA 1 of 26.
Yeah.
Because ultimately, if we decide this, the IA will automatically come along with that. Okay.
Lordship, so since the matter is the same, I will come back to that. It
Because
was
all these dates, this and that is a matter which can be seen only from the records.
Lordship.
And we don't have the lower court records today with us. So we will go by, we'll
okay,
decide
fine.
the FA.
Okay. So on 30th, after disposing the IA, the children were given to the mother. And on the same day, another date was fixed, which was fixed on 16th. On 16th,
No, but first you come to this, whether an appeal can be filed. If
Yes,
it can
very
be
much,
filed
very much.
Against an interim order.
very much. This one. Lordship, let us come to section 19.2 of this Family Court Act 1984.
You don't have any records.
Or I can read. Section 19.
Yes.
Let me read this operative part of subclause 2. No appeal shall lie from a decree or order passed by family court with the consent of the parties. With the consent of the parties. But here, the consent of the parties was not taken. The consent of the party was not taken.
You read clause 1 also, 19 clause 1.
Save as provided under section 2 and notwithstanding anything contained in Code of Civil Procedure 1908, 5 of 1908, or in Code of Criminal Procedure so and so, or in any other law, an appeal shall lie from every judgment or other order being interlocutory.
Not being. Not
being an interlocutory order, or a family court or high court, and so. But in second, we are coming to the second. We are supporting our submission by a ruling of the Supreme Court.
Two will come first or one will come first?
No, the parties have stated that it
Because
cannot,
2, 3,
interlocutory
clause
cannot
2,
cover an
3,
appeal.
4, 5, 6 are all corollary to 1.
Exactly.
1 will come first.
Exactly.
So
But-
1 says, an appeal shall lie from every judgment and order, not being an interlocutory order.
Lordship, I will explain to that clearly now. So, when we come to the second point, we cannot just exclusively take one, but we have to come into all points. So, second say that when two
every
parties have,
judgment and order, see, you read it together. An appeal shall lie from every judgment and order which was not obtained with consent of both parties.
yes,
But not in interlocutory order.
let me, in order to substantiate this clearly, let me read this.
Okay.
Lordship, this case is in Ricardo Shah Babulal Khimji versus Jayapenti Kanya and another. Let us see para 115, Lordship. Para 115. Shall I read?
1 minute. Para 115.
115. $115.
Yes.
Shall I read?
Yes.
Lordship, it says, thus, in other words, every interlocutory order cannot be regarded as a judgment, but only those orders would be judgments which decide matters of moment or affect vital and valuable rights of the parties, and which work seriously injustice to the party concerned. Similarly, order passed by a trial judge deciding question of admissibility or relevancy of a document also cannot be treated as a judgment because the grievance on this score can be corrected by the appellate court in appeal against the final judgment. So, this is interlocutory order. Since interlocutory order has affected the interest of the children, that is why this is appealable. And for that reason, we have cited that section 19.2. Now, section 19.2 says that...
You show me a judgment regarding Family Courts Act. This is not regarding the family court.
Yeah, this is family court.
No, this Family Courts Act section 19 specifically. Because this is a purely interlocutory order, the interim custody of the children.
We thought of producing this in the main, but since we are taking up the issue, I'm coming up with this. Lordship, I'm sending for the book, but meanwhile I can read this and highlight you. This is a case passed in 2024. Supreme Court cases online. Supreme Court, page 847. Before Vikramnath and Satish Chandra Sharma,
No,
Justice.
give the citation. Citation
2024
2024.
SCC online SC page 847.
847.
Lordship. And then the parties are Colonel Ramnish Pal Singh, appellants, versus Sukandi Agarwal, respondents.
Okay.
I will bring the book. Meanwhile, I will
Yes, yes, you
read this. At para 10 of the judgment, it states, in our judgment, the law relating to custody of a child, this is right, this judgment, is a fairly well settled, and it is this in deciding a difficult and complex question as to the custody of a minor. A court of law should keep in mind the relevant status and the rights flowing therefrom, but such cases cannot be decided solely by interpreting legal provisions. It is a human problem and is required to be solved with touch. A court, while dealing with custody cases, is neither bound by statutes nor by strict rules of evidence or procedure, nor by precedents. In selecting proper guardian of a minor, the paramount consideration should be the welfare and well-being of the child. In selecting a guardian, the court is exercising parents' patriot jurisdiction and is expected.
Mr. Pius, this is regarding the merit of the case, how
Yes.
to decide the merit.
Broad.
But right now, what we want to know is whether appeal lies under Section 19 of the Family Courts Act against an interlocutory order giving custody.
That is what I have. That is what I have already referred. Section 9. This is from family court only. This is from family court only. I'm reading.
That's
That
right.
is-
In Family Courts Act, Section 19, it specifically states that an appeal shall lie from every judgment and order not being an interlocutory order. So you have to address the court on that,
Lordship, as regard to
not
this,
on how to decide the merit.
Lordship, as regard to this interlocutory order, if you see this order from para 113 of this judgment, everything is very nicely stated. First, A, final judgment. 2, preliminary judgment. 3, intermediary or interlocutory judgment. It is given here in the same judgment.
This
So-
2024 SCC online.
No, the one which I've given the book.
No, but this is not Family Courts Act.
No, but I'm referring from here. I'm referring from family court. I'm referring
See,
from
this is
family court.
CPC, this is CPC, this judgment.
No, but we are talking about the, this interlocutory rules. Nah? We are talking about the interlocutory rule. That is why from here we have found this judgment.
No, you're not getting my point.
No, I'm getting your point, but
this judgment is with regard to CPC, general CPC. Okay, and what the court is asking you is to get a judgment on whether against an interlocutory order granting custody, an appeal can be filed under Section 19 of the Family Courts Act.
Lordship, for that reason, I'm citing the second order wherein it says that it can be because
This
court
is an
cannot
appeal
decide.
like under Section 19.
No, this speaks about the custody of the children, so it is
No,
related.
custody is different. Custody is different. That is on merit. That is merit. Okay, anyway, any other judgment? We have noted, yes, I have noted para 10 in this judgment and then para 113 here. Then any other?
Para then para 12,
Para 12.
para 12. Shall I read the contents of para 12?
Okay.
Accordingly, in view of the aforesaid, not only must we proceed to decide the present list of the basis of the holistic and all-encompassing approach, including inter alia, the social, economic, and educational opportunity which may be made available to the minor children, the healthcare, the overall well-being, the ability provided physical surrounding conducive to growing adolescents, take into consideration the preference of the minor children as mandated under Section 13(3) of the Act. It means the desire of the children. Then 13 says, In the present factual matrix, the minor children example, SSU and SSH have interacted with their courts to express a preference of guardian on their plethora of occasions. Accordingly, we consider it appropriate to briefly tap on the
No,
observation.
even that is on the merit only, that is not on maintainability. Okay, now you go to the merit then.
Now,
On what grounds have you come before this court?
now, Lordship, after this honorable court was had revoked the stay order granted on
No,
6.
no, no, we won't go to that.
So, the children-
But the grounds on which you have filed the FA, you come to that now.
The FA was filed for the fact that the respondent in the main case, he used to give false narrative in spite of the fact that the situation is different. Accordingly,
Okay, 1 minute. Respondent, give false narrative.
false narrative.
Okay.
Now, false narrative, we have already heard, I didn't attend the day when the hearing on that FA was only granted, all this, so the stay order should be vacated. They stated that they were managing the children, whereas we have all the certificates, cash members, where we have been managing the children. The respondent has said that she used to come and give khana to the children, whereas at no time she has come to give khana. Sometimes she used to come
At the
and
time of passing the impugned order, where were the children? The children were
with the father. And even now, after the vacation was done, the children were with the mother. The mother came. The father was not there. Now the children had a fight with the mother. We are not coming to you. We are staying with the father. So he convinced the younger son somehow, and the younger son told her, if you are taking me, I'll not stay with you, but after the exam, I'm coming back. And he has shown an affidavit for that also. So when the children not at all happy to stay with the mother, how can the court order direct the children to be with the mother if something happens to the mother?
So basically, you are saying that the impugned order was passed on the basis of false presumption.
Submission, yes, false submission by the opposite party. Because we have been listening to the submission through this video, and then we were shocked because mother at no time come to take care of them. When they are sick, the father goes. All the school's bills are given to the father. Now she's claiming that I'm taking care of all of them. Then where is that? So there was a big fight between the children and the mother. So my humble submission before this honorable court is that let this case be disposed of from here and give a direction to get first-hand information to let the children appear before the family court and take the statement. We have no objection for that. Let the children appear before the this family court, take their statement from there, and let the court decide. That is the only way it means here, because these successive judgments have said that the preference of the children should be taken. So now the children doesn't want to stay with the mother.
Okay.
So ultimately that will be, in spite of all these facts, since the respondent has been giving a false narrative, in order to settle the issue, this court may be pleased to direct the lower court to call for the two boys who are staying with the mother and take their statement and dispose of the petition according to that. Lordship, I would like to clarify before the Honorable Court that eldest son is still with the father. She told the mother, don't call me. I don't want to stay with you. The younger son told the same thing, but the mother said, no, I will take care of you. I'll see all this. But then the boy said, the youngest one, you promise that you will send me back after the exam, otherwise I'm not coming. So that was a conditional they have discussed, and then the younger son is with the mother now. After the exam,
Those
she'll
things
come
the
back.
trial court will decide after,
So-
after meeting the children.
Lordship, that is why my humble submission before this honorable court is that instead of the playing with the life of the children, give a direction to the children to appear before the trial court and let the trial court decide as per the wishes of the children. That is my humble submission before this honorable court.
Okay.
Really, regarding the maintainability of the appeal, my learned senior, he has referred to a judgment. So referring to a judgment, full bench, this is a full bench, Bombay High Court. Sunil Hansraj Gupta versus Payal Sunil Gupta. This was passed in the year 1991. So if your lordship will come to
Yes, the relevant.
the relevant portion, page 16, page numbers are in the bottom, my lady. 13A. To sum up, we hold that the present appeal filed under Section 19(1) of the Family Courts Act against the interlocutory order is not maintainable. And the Kemji case is also discussed in this judgment, my lady.
This one?
Yes, this judgment is also discussed. The Kemji judgment is also being dealt with in this case, my lord. And my lady, this court has the inherent power under Section 151 to dismiss this appeal.
Paragraph 13, no?
Yes, paragraph 13. 13A, the last paragraph of page 16.
This is also regarding custody.
Yes, similar facts. So this in this case also they refer to the Kenji case,
Yes.
and this case has dealt with other judgment.
Okay.
And my lady, Family Courts Act is a special statute.
Special statute,
Special
yes, that's
statute.
right.
So that has to be kept in mind, my lady. And then, my lady, the order which is under challenge in this appeal, 33/2026, my lady, like my lady said on the first day of the matter listed for motion that day, my lady was also of the impression that it is a very sound order. The family court has passed a very sound order. Both the rights of both the parties have been protected in this order. This is a very sound order. And overnight visitations are also allowed to the father also. And like last winter
Just
vacation.
Let's see the impugn order again.
Yes,
Page.
my lady. Page 118 of the FA. So if my lady will go to the relevant paragraphs of the order, which will start from, if I may allow to take my lady to paragraph 11. May I read, my lady?
Paragraph 11.
It's page number 125. The page numbers are not very clear.
Yes, not.
But it's page 8 of the order, 8 of 22.
Yes, yes.
law. So, upon receipt of the second application, this court ordered for production of all 3 children before the court the next day on 3/3/2026. Upon asserting that the children were
3 children before the court. Yes.
children were safe and fit, and court proceeded to have an interaction with the 3 minor children. Upon first interaction, the children appear well behaved, smart, and cautious. However, upon closer interaction with the children one-on-one, the following observations are recorded. The older child was due to turn 17 on 10/3/2026. She is acutely aware of the acrimonious relationship between her parents, having witnessed the abusive nature of the respondent father towards the applicant mother. She misses their family not being together, but stated that since her parents cannot resolve their differences, it is best that they separate. But it is important to her that she and her 2 brothers stay together. She appeared emotionally affected as a result of the constant disturbance caused by her parents' frequent spats and wishes for it to end. The two younger boys appear to have come prepared for the interaction in that they expressed the wish to stay with the father without the asking or the prompting of the court. The children portrayed their dads as being fun and narrated incidents of going to parks and enjoyment. Their responses exhibited an overt preference of the father over the mother, and their ready-made answers gave the impression that the two sons have been prepared well for the meeting. Therefore, the possibility that they have been tutored cannot be entirely ruled out. The two minor boys are taken care of by a domestic helper who is also a minor boy himself. In the absence of the father, who is posted at Mokchong, the two minor boys are overseen by the grandfather and the domestic help. Now, the husband, now too, he's posted in Dimapur. And my lady, paragraph 14. Owing to deep-seated resentment of the parties against each other and the tendency of the parties to engage in the blame game using court orders as a scratch, the counsellor has chosen to omit the details from her written report and verbally narrate the outcome of the proceedings to the court. The counsellor family court has narrated the following incidents which occurred during the midst of the counselling, which are found relevant for the purposes of considering the instant application and therefore placed on record. Number one, the parties continued to engage in accusatory statements against each other, and neither party was in position to hear the other. The unresolved dispute with respect to the matrimonial home, which is the subject matter of a civil suit, appears to be the main thorn in their flesh. The father-in-law's continued presence during the counseling session was flagged as concerning. At one point, the father-in-law hurled unfounded accusations at the applicant, referring to her as so-and-so in front of the counsellor. The counsellor also expressed her concern about a young minor domestic help overseeing the welfare of the two minor boys in the absence of the respondent. And paragraph 18, my lady. Paragraph 18. This is the report of the counsellor. Upon considering the pleadings, interactions with the parties, and observations of the counsellor, the following findings are recorded. Outside of the marital dispute, the applicant and the respondent have been engaged in an extremely acrimonious battle over their matrimonial property. These unresolved issues from the civil dispute seem to have spilled over to this present custody battle. Unfortunately, the children are caught between the two unrelenting parties, and there is a strong likelihood of the children succumbing as a casualty to the ugly battle between the applicant and respondent, causing profound psychological, emotional, and even physical harm to the children. The parties have been separated for over 4 years now, but their dispute dates back much earlier. A domestic violence case number 2 of 2022 was earlier filed prior to the divorce case, wherein White Order dated 1/6/2022 passed by the Honorable Judicial Magistrate First Class Dimapur. The respondent was restrained from entering the house of the applicant and the OC. Women PS was further directed to ensure that the respondent does not further assault or commit any domestic violence upon the applicant, and to render any assistance as required under law to the applicant. At every session, the parties have engaged in hateful and demeaning accusations against each other without utter disregard to anybody in the room. These actions of the parties strongly suggest that the children would have been exposed to much more negative experiences over the course of the last few years. The children need a peaceful and stable environment in order to restore the family equilibrium. The bond between the siblings requires to be fostered and strengthened, especially since the acrimonious relationship between the mother and the father shows no signs of letting go. For a holistic development, it is imperative that all the 3 children cultivate a healthy relationship with both mother and father. However, that appears to have been severely affected not only as a result of breakdown in the marital relationship, but also due to unnecessary third-party interference. Children require clear boundaries and understanding of parental authority in order to cultivate discipline and obedience, which seem to have been disrupted as a result of the meddling by the grandfather. The incidents leading up to this application, whereby the minor son was taken away by the grandfather without the knowledge or consent of the applicant, suggest a strong disregard for the mother and unwarranted interference by the grandparent. The submission of the applicant that she had to resort to asking for police help to meet her two minor boys suggests that there was an active attempt to obstruct the applicant's access to her minor boys by the grandfather. While this court is not discounting the ability of the respondent as a father, such contemptuous behavior by an elderly member of the family risks negatively influencing the children's mind and could potentially lead to alienating the children from the other parent. From the materials on record, notwithstanding the extremely bitter and ugly history between the applicant and the respondent, the applicant mother appears to be an involved parent keeping up to date with the affairs of the children through regular interaction with the school teachers. The applicant is gainfully employed in government service and has the financial means to provide for the children and has been doing so since their childhood. The applicant is also presently residing in the matrimonial home and is posted at Duncan, Dimapur, which is within the vicinity of the children's school. The minor boys are at age where constant presence and supervision of either parent or responsible adult is necessary. The older son at 13 years of age is now at the stage of puberty, requiring a proper diet, structured routine, and strong emotional and moral support to navigate peer pressure and make healthy independent choices. To leave him without the security and support of a parent risks impairing his proper emotional and intellectual growth. The younger son, at 7 years old, parrots everything the elder brother states, indicating that ensuring a stable and healthy environment for the older son would inevitably aid the proper upbringing of the younger son too. Herein, the fact that the respondent is posted in Bok Chong when the children are all studying at Dimapur and have built a life here since their birth is an important point of consideration. Even assuming that the respondent was posted at Dimapur, the averments in the plains reveal that a hostile environment has been created in his household by him and his father against the applicant mother, which, unless remedied, is highly detrimental to the children's mental and emotional well-being. At the cost of reputation, while the court is not inclined to discount the ability of the respondent as an able father at this point, however, given the circumstances, the applicant mother seems to be better placed to ensure the daily constant upkeep and well-being of all the three children. Might I add that in custody battles, what is relevant for consideration is the welfare of the children and not just the fitness of either parent. Yes.
And then the final direction was?
Yes, the final direction.
Visitation rights of the page 135.
Yes.
No?
And the father was allowed overnight.
Right, second and fourth Saturday and
Yes.
Sunday. We would like to know. Shall take custody of the minor boys from 10 a.m. to 7 p.m. Custody of the children during long breaks shall be shared 50-50. Every day, from 7 to 8. We have to have joint legal custody. Okay.
So this is a very sound order. Both.
Okay, yes. Heard learned counsel for the appellant, Mr. Kailas Lata. Also heard Ms. Rostina for the respondent. Disposal. No, chamber disposal. Okay. And you give that other judgment.
Your Honor, we couldn't get the copy, that is why we are giving that one which we have called.
Okay. Just send it to the chamber. This one also.
Obliged me.
Orders, item number 11. Please, Your Lordship.
Yes.
Lordship, I already my affidavit of compliance, instrument the respondent number 4 by way of trustee.
Done.
Yes,
You
my
have
Lord.
filed.
Filed on 20/04/2026, my Lord.
Yes.
He has refused to accept
Learned counsel for the petitioner, Mr. A. Swafi. So, Learned Additional Advocate General, Mr. In Kim Song, is present for the state respondents. So, as far as the service on respondent 4 is concerned, the learned counsel for the petitioner has taken steps by Dusty and has filed the compliance affidavit on, when did you file?
2004
On
2026.
20/04/2026. So, accordingly, the service on respondent number 4 is deemed served. So, none appears for the respondent number 4 when the matter is called. So, will you be filing any
Lordship,
affidavit?
going to the nature of the case. Now, the decision given by the overseas court could not be implemented. So, for which the petitioner has approached a administration in order to implement the decision of the overseas court. So, in such a case, if the direction is given to the respondent 2 and 3, it is sufficient time. I believe that that will meet the
Do
purpose
we
of the
need
decision.
the records? Records will be necessary
Not necessary.
to direct the customary court and to execute it.
The customary court is refusing to execute its order dated 14/05/2024. my lord. So I'm producing a copy that to direct the customary court to execute its order.
Okay. The learned counsel for the petitioner, Mr. A. Sophie, submits that the facts leading to the filing of the instant petition is that where the facts starting from on 4/11/2022, the Rosazo Village Council initiated a process to construct a VIP helipad for the welfare of the public. Stop. The village council started the process of acquiring land for the said project, and thereafter 18 landowners, including the respondent number 4, verbally agreed on 12/12/2022 to give their land in lieu of compensation or grade 4 post, and some landowners freely donated their land. Stop. On 22nd December 2022, the construction and development of the said project started, and this helipad was inaugurated on 1/6/2023. Stop. Para. The respondent number 4 also verbally agreed and gave his land for the construction of the said project. Stop. On However, once the project was completed and inaugurated, the respondent number 4 started constructing a house in the middle of the helipad on 27/2/2024. So, the petitioner village council therefore objected to the construction of the house by the respondent number 4 at the helipad. However, no positive steps were taken by the respondent number 4. So the petitioners therefore approached the EAC Secruzopec, is it? The petitioners approached the EAC Secruzopec with their grievances by way of a complaint on 3/3/2024. Stop. Para. Thereafter, the customary court of DBs, EAC office Secruzopec took up the matter and registered the complaint as case number 557. Stop. After recording the statements and hearing both the petitioner and the respondent number 4, the DB's court passed the order dated 14/5/2024. Stop. Para. As per the decision dated 14/5/2024, The petitioner village council was directed to pay rupees 7,29,900, 7,29,900 only in 2 installments to the respondent number 4 as compensation for the land which he donated for the project, and also for the standing trees upon his land. And thereafter, the land of the respondent number 4 would belong to the village council. Stop. Further, the respondent number 4 was also directed to remove the house which he had constructed in the middle of the helipad. Stop. Para. It is the case of the petitioner that they have deposited the amount of rupees 7,29,900, abiding by the decision of the Dobashis dated 14/5/2024 before the DB customary court on 9th July 2024. So, the petitioner also states that the respondent number 4, however, refused to comply with the decision dated 14/5/2024 to remove the constructed house from the helipad. And accordingly, the village council / petitioner on 4/10/2024 wrote to the DB's customary court EAC office, Secretary, praying for execution of its decision / order dated 14/5/2024. However, the DB's court refused to exercise its power to execute the said order. Stop. Thereafter, on 3/7/2025, the petitioner village council again wrote to the additional deputy commissioner Chazupa Peg, Nagaland, and on 26/9/2025 to the deputy commissioner Peg, Nagaland. Stop. However, till date, no direction or actions were initiated for the execution of the order dated 14/5/2024. So, para. The petitioner further submits that the respondent number 4 has not filed any appeal against the DB's court order dated 14/5/2024. Accordingly, the instant application has been preferred by the petitioner under Article 227 of the Constitution of India, praying for invoking the supervisory jurisdiction of this court and to direct the DB's customary court, EAC office Secretary to execute its decision / order dated 14/5/2024 in case number 557. Anything else? That's all, no?
That's all, my lord. My lord, the money which I deposited was returned to me.
Was returned?
Yes, my lord. Since the respondent number 4 refused to accept the money, it was again returned to me by an order dated 13/08/2025. It is at page number.
Where have you stated that?
It's in para 11, my lord. Para 11.
Okay. The petitioner further states that on 13/8/2025, the DB's customary court, EAC office, Secretary has returned the compensation amount deposited by the petitioner, stating that the respondent number 4 has refused to take the compensation amount, and hence the same has been returned, and hence the same is being returned to the petitioner village council. The learned additional advocate general Mr. Im Tim Song submits that the instant petition can be disposed of with a direction to the respondent number 2, I think, respondent number 2 and 3, to the respondent number 2 and 3 to implement the decision / order dated 14/5/2024 passed in case number 557. As till date, no appeal has been filed by any parties against the said decision. Stop. Para. Upon consideration of the submissions made by the learned counsel for the parties, and upon perusal of the pleadings and the documents annexed in the petition, the instant petition is disposed of with the direction to the respondent number 2 and 3 to implement, to ensure that the DB court's decision / order dated 14/5/2024 is implemented. The petitioner shall also should also be allowed to deposit the compensation amount. Is it?
Yes, my lord.
Allowed to deposit the compensation amount of rupees 7, 29,900 before the customary DB's court. Within a period of, I think, some time frame should be given.
3 months.
Within a period of 3 months.
3 months.
From the date a copy of this order is served on the respondents. The above directions, the petition stays disposed.
Orders, item number 12.
Please, my lordship. Lordship, I received their affidavit in opposition. Affidavit in opposition this morning. And Lordship, I will just like to clarify before this honorable court. In all the 3 writ petitions, their affidavit in opposition is all the same. Same contents. Now, my just humble clarification before this honorable court from the respondent is
this the case where an IA was filed? An IA or what was filed?
This morning.
yes.
Has it come?
My only humble submission before this honorable court is, legacy, that my review petition is pending before the division bench at the HOC. So this content proceeding may be
Keep pending.
I'll apprise the court also at the outcome of my IA, my review petition.
And this IA is for?
This IA is for the order that has been passed by the division bench to seek clarification from the Honorable Supreme Court. We went to Supreme Court has clarified saying that you go to division bench, file the review, your appeal was not heard on merits, let your appeal be heard on merits and then dispose of. So therefore, my review is pending before the division bench. I have mentioned this in the last month of 16th of June and supposed to be listed tomorrow.
I have a submission to make with the permission of the court.
Yes.
Please. This is a matter which has been going like a pendulum from the High Court to the Supreme Court to and fro. And since we had not complied with the court orders, we were in contempt. That is how the contempt notice was issued. So last time we had filed an affidavit that we will go ahead with the advertisement proceedings because there is no stay from any court as far as we are concerned. So in this present petition, at page para 13, we have given an undertaking that the publication will be done by the 3rd week of August. This is what we have said. So therefore, which means the process of total compliance will be seriously undertaken by the third week of August. I would only suggest that this matter may be listed immediately after that, by which time we would have taken the serious step to go ahead. Then as far as matters go pending here, pending there, actually, we have not got any stay. The state itself had taken this type of defense earlier, which was not allowed. So now, since the petitions have been dismissed from various courts without any stay from any court, and on the other side, we are facing contempt from the petitioner, we are willing to comply with it. That's why we filed the affidavit. If they get any order from any court or anything, that's a different thing. As on date, we stand by the commitment we have made that by third week of August, we'll go ahead with the publication, which means the process will start. I don't think my learned friend could have anything to say on this.
Third week August. They have no way out.
Lordship,
Yes.
just my humble clarification before this Honorable Court and before the Honorable AG. Lordship, here in their affidavit in reply, since it's all the same, I'll just point to paragraph 5, page 4.
Affidavit in opposition on
Yes,
behalf of
yes,
respondent
of
1.
the respondent that I received this morning.
Paragraph 4.
Paragraph 5, but in page 4. Last, here, regarding 2 writ petitions for constables, one is 100 and one is 934 in one writ petition. Yes, 194, and in one is 174. So a total of 1,098 posts that was placed before this Honorable Court, covered by this Honorable Court's order. Now in their paragraph 5, 10 is missing. The last paragraph cite recruitment for the post of 178. They said 178, that means 20 posts is missing from the post that was placed before this Honorable Court. So this clarification, I need the petitioners.
So you're saying there should be total 1,098 posts?
98 posts, yes, including both the writ petitions. So where did that 20 posts?
If there is a discrepancy, we'll look into it. It must be already there.
Yes,
You
yes,
clarify.
but I also need
Yes.
clarification.
So you
the
clarify on the next date. It's
Yes,
okay.
and also,
Yeah,
Lordship will kindly come to paragraph 8. This is for ASI, UBSIs and SIs. So paragraph 8, in the subsequent 2 other writ petitions also this can be covered, Lordship.
Paragraph 8. Starting
Paragraph
from in
right?
September 2024, this one.
Paragraph 8 is no in the same
You're referring to whose affidavit?
in the
Respondent
same
2.
number 1.
Respondent number 1.
Yes. Paragraph 8 is 24 assistant sub-inspectors.
Paragraph
8.
No, the affidavit of R1 is only up to 7 paragraphs.
Up to 7 paragraphs, then this is Acha, Lordship,
I think you're talking about respondent 2.
2, maybe 2, Lordship.
Respondent 2.
This is respondent 1. Also, also.
No, it's different.
This is
Respondent
16. I'm pointing out from COP 16, Lordship.
Yes, you'll be
Yes.
16.
Then if it is that, I have paragraph 8 also. Whether it's
Yeah, there is. It's up to paragraph.
It's up to paragraph
14.
7 only.
No.
Or there are
8
some
is
other.
there. 8 is there. In COP
The 1 to
16.
15.
No, just see. Is it this one? Solomon, just give this.
No, this is not one.
That's not the one.
Yes.
Where is it?
I think we filed only this morning. So the filing session has
It has
granted
not
on
come
it.
on record.
Yes.
Acha, that's why. So you have filed on behalf of
All the respondents.
Okay.
My lord, can
Additional affidavit. Maybe.
No, affidavit of opposition.
Affidavit of opposition.
Lordship can just peruse this. It's all the same. All the paragraphs are same.
These are also affidavit in opposition.
Yeah. But it was filed on, might be filed by the DGB.
24th April 2026. This is affidavit
I'm
on
just reading
behalf
out
of
from
respondent 1 and this is respondent 2.
No, but now we have, it should be in the form of an additional affidavit.
Must be additional
Yes.
affidavit.
They are saying affidavit in opposition.
Yes,
Rested respondent number 4.
It should be additional affidavit.
additional affidavit.
Okay, because earlier
Okay.
they have already
Yes.
filed
Okay.
affidavit in opposition.
Eh,
Do you have those copies? Earlier which they have
I
filed
don't think.
in April 2026.
Lordship,
They are filed on 24th April 2026.
yes, Lordship, I have it.
Yes, so
But
those are affidavit in opposition.
Okay.
Now
So
it
this
should be
one should have
additional.
been additional
Additional.
affidavit. Otherwise,
Otherwise
confusion
it's-
will be created.
I think this was prepared during the vacation, where there are so many communication gap at home.
You
Because
correct,
of-
you
Yeah,
correct
I'll take all the
the
rectification.
course title and the covering page, the cover page. Okay, yes. What you say?
Paragraph 8. I just want clarification from the respondent government. Paragraph 8 says 24 assistant sub-inspectors.
Paragraph 8 of this is
Respondent number 4. Here they say respondent number 4. Affidavit for and on behalf of the state respondent number 4. "24 sub-inspectors." Lordship, allow me to read out. That with regard to this Honorable Court's judgment dated 26/9/2024, passed in writ petition number 317/2023, in respect of 24 sub-inspectors, ASIs of Nagaland Police, through the letter dated 1/7/2026, the Director General of Police Nagaland was requested to submit proposal to place requisition for recruitment of the 24 ASI posts to the NSSB, as ASI post also carries a pay level for which NSSB is mandated to conduct recruitment. In respect of 12 unarmed branch sub-inspector UBSIs affected in the order passed on 26/9/2024 in writ petition 317/2023, one incumbent was reported to have subsequently resigned in the meantime, and therefore a proposal was to be made for placing requisition of 11 UBSI posts of Nagaland Police to the Nagaland Public Service Commission NPSC, which is mandated to conduct recruitment for the posts of the pay level which as ASI post carries. Further, the Director General Home Guard CD and SDRF was also requested to submit proposal for place requisition of 2 sub-inspector SI posts which were affected in the judgment order passed on 26/9/2024 in writ petition civil number 317/2023 to the NPSC. Now, my lord, will kindly see here the post placed before this honorable court is 38 posts. Now 24 plus
in WP 317.
In WP
317 of 23.
Yes, Lordship. This is UBSI.
38, you're saying?
Yes, 317.
Yes,
In 317.
317.
The other two are constables.
Yes.
And this 317
So in
is for the
317,
Yes.
you're saying that it should have been 38 posts.
38 posts was placed.
and
Yes.
not 24.
No, 28 plus 24. Now they are saying that one resigned. Nevertheless, whether resigned or not, the post should be 38, that is to be placed before the NPSC or NSSB. ASI, UBSI.
Okay, we will just direct them to clarify.
Yeah, clarify. 3 is missing. 3 posts is missing. That's all.
Okay, we'll first pass order in the COP, okay, COP 16. Heard Ms. Z. Zimomi, learned counsel for the petitioners. Mr. Im Tim Song, learned additional AG, appears for the respondent number 2, and Mr. N. Longomer for respondent number 3. No, we'll say Mr. N. Balgopal, learned additional advocate general, appears on behalf of respondent number 2, along with Mr. Im Tim Song, learned additional advocate general. Okay, and Mr. N. Longomer appears for the respondent number 3. Stop. The learned Advocate General, Mr. K. N. Balgopal, submits that the state respondents / respondent number 2. Respondent number 2 is Abhijit Sinha or
Abhijit Sinha.
Yes, respondent number 2 has filed an additional affidavit today, this morning. So, he also submits that the entire exercise as directed by this court in WPC 189/2022 and analogous writ petitions will be completed by the 3rd week of August 2026, and therefore prays that the matter may be listed after
The 3rd week
of August 2026.
A specific date can be given, Lordship.
We will give a date.
towards the
Yes, at this stage, the learned counsel for the petitioner, Ms. Z. Zimomi, submits that there is a discrepancy at paragraph 8 of the affidavit filed by the respondent number 2 / state respondents, in as much as the total number of posts of ASI in WP 317 of 2023 was 38 posts, whereas in the additional affidavit of the state respondent / respondent 2, it is portrayed as 20.
24.
It should be 38, but it is shown as what?
24.
38.
It should be
35,
38, but it is portrayed as 35. Okay,
Yes,
stop. And she therefore prays that the respondents may be directed to verify the said number on the next date.
Lordship,
Yes.
this is pertaining to COP 39, the present UBSI SI. In all the affidavit, additional affidavit, the paragraphs are all the same. That's why just in COP 16 I was pointing out. And
Anyway, there also it is at paragraph 8.
Yes, yes,
Same.
everywhere.
All the same.
everywhere.
It's okay. So, accordingly, list the matter. 3rd week of August. Yes, Advocate General, please give a date of the 3rd week of
any and towards the end of the day, August,
or September 1st week.
September 1st week.
On 1st September, because 2nd is Wednesday, so 1st September. Okay.
1st September.
1st September 2026. So that is then we come to the IA. Any objections in the IA implement? You have received copy.
Which one?
We just received.
We'll examine it.
I'm going on the phone 4 hours. I haven't received it, I don't know, just now.
We will examine that. We have not read what the IA is about.
In that case, let
No,
us.
If it's coming up tomorrow, because of this pending, it may not affect the content petition. What is the use? They are saying that they might be saying that this judgment may not affect them. That may be the ground. Otherwise, I don't know
It will
why.
affect them once if the state is to take
Of
any
course.
step. It will affect my service.
Yes, because you are
But
appointed
my-
through that door.
Wait. The instant application for this is IA 150 of 2026. Okay, the instant application for implement has been filed, praying for implement of the petitioners as respondent number 5 to 9 in the pending COP number 16/2025 pending before this court. Stop. Third General Counsel for the petitioner, Mr. Such and Such. Stop. The learned counsel for the petitioner, Mrs. Zimomi, submits that she is yet to receive a copy of the petition. Stop. Accordingly,
Yes. Okay, sir. She has received.
Only now, yeah, before
only
the
now,
Honorable
only
Court.
now she has received. So we'll consider it maybe after a week
Yeah, Lordship.
regarding the implement.
Lordship.
Least after a week, okay, for consideration. You have received a copy?
Just now.
Okay, did you also? Yes. Learned Additional Advocate General, Mr. Im Song, has also submitted that he has received a copy of the said application only this morning. Stop. And therefore prays for some time to go through the same list after 1 week. Yes.
Worship, regarding the rectification of the additional affidavit, that will be reflected in the order. Rectification of the.
Yes, the learned additional advocate shall also make necessary rectifications in the affidavit filed today in the cost title and the heading of the application. So, yes.
Obliged, Lordship.
Orders, item number 13.
I think these are all connected. 13 and 14, I think. 12, 13 and 14.
Yes,
Yeah.
yes, Lordship.
12, 13 and 14 are
Same
all,
order.
it will be covered by the same.
Item number 16. Item number 16.
Vizi Momi.
He was there. On the last occasion, LCR was called.
Yes. LCR has been received. Just see. Scan copy. No. Learned counsel for the petitioner, Mr. Nisuka Chishi, is present. Stop. On 23/6/2026, this court had called for the scanned copy of the case records from the special court NDPS Zenepoto. Stop. Office note dated 10/7/2026 indicates that the scanned copy of DCR is awaited. Stop. The registry shall issue another reminder to the special court NDPS Zenepoto to transmit the scanned copy of the case reports. Stop. List after 2 weeks.
Obliged, Lordship.
Item number 17.
Here also Mr. Zimomi. Case diary. Call after some time. You inform the PP. Who is Zimomi? Yes, just call next set.
Item number 19.
May I please, Your Lordship? Lordship, on the last occasion, I prayed before this honorable court to implement the new incumbent, that is respondent number 5. And accordingly, this honorable court has allowed to file the IA,
Okay.
Lordship.
Heard learned counsel for the petitioner, Mr. Such and such. Stop. Para, the instant application has been preferred, praying for implement of the new incumbent, namely Engineer K. Nikato Asumi, as respondent number 4 in the connected COP civil number 11, number 11, right? Number 11 of 2026. Stop. Para. The learned counsel for the applicant submits that during the pendency of the COP civil 11 of 2026, the erstwhile respondent number 5, who retired?
No, Lordship transferred.
The erstwhile respondent number 5 has been transferred and is no longer holding the post of chief engineer. Stop. In his place, the respondent, Mr. Engineer K. Nikato Asumi has been transferred, has been promoted as chief engineer, Nagaland PWD, housing, Nagaland. So, in view of the said transfer/promotion, the instant application has been filed in order to implement the new incumbent for proper adjudication of the contempt petition number 11 of 2026. Stop. Para. Upon consideration of the pleadings and the submission of the learned counsel for the applicant, the instant application is allowed. The applicant shall file an amended cause title implementing the new incumbent Engineer K. Nikato Asumi as party respondent number 4 in the pending contempt petition COP civil number 11 of 2026, and thereafter within a period of 4 working days from today, and thereafter take steps for service on the newly implemented respondent number 4 by speed post as well as usual process within 3 days thereafter. Stop.
Much obliged.
In the main COP, you say, in view of the order passed in IA number, what is the IA number? In IA number 144 of 2026, lists the matter after 2 weeks.
Lordship. Much obliged.
Miss S. Chang is present for, you are present for which respondent?
For respondent 1, Lordship.
For respondent number 1.
On behalf of N. Angami.
On behalf of N. Angami. Yes. Case diary has come.
Lordship, I may lost some a week's time, Lordship, to get
This is from Kifire.
No.
Learned counsel for the petitioner, Mr. Tushi Tamjan, is present. Stop. Learned PP, Mr. Vijimomi, submits that he is yet to obtain the scanned copy of the case diary. Stop. He therefore prays for another 1 week's time to produce the same. Stop list after 1 week. Tell them to send scanned copy by email. Next.
Item number 20.
Implement. Oh,
Your
what is
Lordship,
this IA?
Your Lordship, the present IA has been filed for deletion of certain petitioners who are
Deletion.
not, yes, who are not covered by the ON.
The instant application under Order 1 Rule 10 Clause 2 of the CPC has been filed by the applicant/petitioner praying for deletion of the names of the petitioners number 1, 6, 7, 18, 102 and 103 in the pending COP civil number 2 of 2025. So, Learned Counsel for the applicants. Miss such and such, stop. Para. The applicant/petitioners submit that the petitioner number 1, that the petitioners/applicants had filed the civil original contempt petition number 2/2025 on 11/3/2025 for non-compliance of the order dated 13/5/2024 passed by this court in WPC number 178/2023 for regularization of services under the office memorandum dated 17/3/2015. Stop. Para. It is stated by the Learned Counsel for the applicants that during the pendency of the present of the contempt petition civil number 2 of 2025 and upon verification of records, it has come to the knowledge of the applicants/petitioners that the applicant/petitioner number 1, 6, 7, 18, 102 and 103 are not covered by the office memorandum dated 17/3/2015 and for which the said applicants/petitioners no longer wish to press the contempt petition. So, it is therefore prayed that their names may be deleted from the array of applicants/petitioners in the civil original contempt petition civil number 2 of 2025. So, Learned Counsel, Ms. S. Chang is present for the respondent number
1 on behalf of N. Angami.
On behalf of N. Angami and has no objections. So, accordingly, the prayer is allowed and the application stands disposed. The petitioner shall be, the applicants are allowed to strike off the names of the petitioners number 1, 6, 7, 18, 102 and 103 in the pending contempt petition civil number 2 of 2025. Application stands disposed. Or you just add one my para, say that the registry shall also do the needful.
Item number 20.
This year is there. Yes, what is this?
Lordship, this is a convicted case man.
Against conviction?
Yes, against conviction man. The gist of the case is that, my lord, the revisionist, while driving one pickup truck in Long Leng, made an accident on 2/12/2024, where he was carrying 7 occupants. Made an accident, my lord. Unfortunately, in that accident, 2 persons were succumbed to the injuries. And then, a suo motu FIR was filed, my lord. Then the case proceeded, and the charge sheet was filed by the alia of the case. The revisionist was summoned and he appeared before the court. along with his counsel. And as per the judgment, my lord, he pleaded guilty, my lord. Yes. And he was convicted for 6 months. And, my lord, after more than 3.5 months, the revisionist appeared before this honorable court, and by filing this revision petition, when he was granted bail, my lord. If I may take your lordship to the grounds, my lord, for filing this revision. Page number 9, my lord. Ground E.
Yes.
Page number 9, ground E. For that, the GR number 34/2024 is illegal for non-compliance of section 351 of the BNSS. The trial court did not put proper and specific questions on the material point touching the facts and circumstances that appeared against the revisionist in order to provide him the opportunity to explain his defense position and also to provide prove his innocence. On this ground, the impugned judgment is liable to be set aside. And page number 10, my lord, I'll be reading only the relevant grounds, my lord. Page number 10, ground H. For that, revisionist is entitled to acquittal in view of the materials on record. He is entitled to acquittal on benefits of doubt as the prosecution miserably failed to prove the guilt of the revisionist beyond all reasonable doubt as required in criminal cases, as such a judgment is illegal, involved without jurisdiction and liable to be set aside forthwith in the interest of justice. I. For that, the trial court convicted the revisionist on the basis of charge sheet submitted by the investigating agency against him. To convict a person on the basis of circumstantial evidence, there must be a change in the evidences, but in this case, there is a break in the chain. The investigation was not proper, and therefore the impugned judgment is liable to be set aside. Ground J. For that, the revisionist is an illiterate person who does not know the consequences and has pleaded guilty as because his counsel has tutored him to do so, and moreover, the revisionist did not understand English language, and thus there is a lack of communication between him and his counsel, and thus he pleaded guilty. Ground K. For that, the judgment of the trial court is bad and not tenable in law, as because the trial court convicted the revisionist under section 281, 106, clause 1, 117, clause 2 of the BNS 2023 solely on the basis of the charge sheet submitted by the investigating agency, and therefore the impugned judgment is liable to be set aside.
Let's see the judgment.
Judgment is at page number 21. Is it married, Manor?
Yes.
Para, Manor. The case of the prosecution is that on 17/7/2024, the accused, while driving a Toyota pickup truck bearing registration number so and so, met with an accident, killing 2 passengers and grievously injuring the 4 others below Orangkong village. Hence, an FIR was filed and it was registered as Nonglen PS case number so and so under section so and so. The case was investigated by SI Chingyang Pom and charge sheet was filed under section 1 so and so. After perusing the charge sheet and the documents placed on the court, there are grounds for presuming that the accused has committed the offenses punishable under section 106, 117, 281 of the BNS. Hence, formal charge is hereby framed against the accused under section so and so. The charge was read over and explained to the accused, to which he pleaded guilty. The guilty plea statement of the accused was recorded and annexed along with the case report. Hence, the learned counsel on the guilty plea of the accused and the same was found to be voluntary, hence it is hereby accepted. The accused is accordingly convicted under section 106, clause 1, 117, clause 2, and 281 of the BNS. Considering the rash and negligent act of the accused has caused the loss of 2 lives and grievously injuring 4 others, I am not inclined to extend him the benefits of the probation of offenders sentencement. The learned APP argued that after the accident, instead of helping the victim, the convict fled the scene and absconded. Hence, he argued to sentence the convict according to the strict provisions of the law. The convict submitted that he fled the scene as he feared for his life since people started gathering at the accident site. He also submitted that he has to look after his wife and 3 children since he is the sole breadwinner of his family. Hence, he prayed to show leniency in his sentence. The defense counsel prayed to show some leniency while sentencing the convict. Due to the rash and negligent act of the convict, 2 precious lives were lost and 4 people suffered grievous injuries. Thereafter, he fled from the accident site instead of helping the victim and remained untraceable without an explanation for more than a year. Therefore, considering all the following sentences is hereby imposed upon the convict. 6 months simple imprisonment for commission of an offence under Section 106 Clause 1 of the BNS. He is also directed to pay a fine of 10,000 only. In default of the payment of fine, he shall undergo a simple imprisonment of 2 months.
Okay, okay. So basically, there was no trial.
No trial. Yes. Being a layman, under the instructions of his counsel, he pleaded guilty. And regarding that, if I may be allowed to raise one authority.
Some judgments are here. 1965 SCC lines.
It was already provided at the motion stage, but I'm providing extra one.
Same one.
Yes.
Same one is here. Then
Page number 3, para number 6. Is my favorite mark. Para number 6, third para mark. It is stated by the magistrate in his report that the particulars of the offence were explained to the appellant by the bench clerk, Sri M. Sukumara Rao, and that the plea of guilty by the appellant was interpreted to the court by the same bench clerk. It is manifest from the report that the admission of the appellant has not been recorded as nearly as possible in the words used by him, as required by Section 243 of the Criminal Procedure Code. It is true that in the judgment dated March 22, 1963, the magistrate has said that the appellant pleads guilty, but the record contains no indication whatsoever as to what exactly the appellant admitted before the magistrate. In our opinion, the requirements of Section 243 of the Criminal Procedure Code are mandatory in character, and a violation of these provisions vitiates the trial and renders the conviction legally invalid. The requirement of the section is not a mere empty formality, but is a matter of substance intended to secure proper administrations of justice. It is important that the terms of the sections are strictly complied with, because the right of appeal of the accused depends upon the circumstance whether he pleaded guilty or not. And it is for this reason that the legislature requires that the exact words used by the accused in his plea of guilty should, as nearly as possible, be recorded in his own language in order to prevent any mistakes or misapprehension. It has been held by the Madras High Court in Queen's Empress versus Guru Gadu that the violation of the procedure in Section 243 of the Criminal Procedure Code was sufficiently serious to invalidate the conviction of the accused. The same view has been taken by the Calcutta High Court in Shalabala Dasi versus Emperor and by the Allahabad High Court in Mukandi Lal versus State. In our opinion, these cases correctly lay down the law on the board.
but then counsel was also there. You had a defense counsel also, isn't it?
Yes, madam. But under the instructions before going to the trial, since he did not understand the language, he does not understand Nakamis nor English. Under the instructions of the counsels, he pleaded guilty, not knowing the consequences of pleading guilty.
The name of the accused is Shahidul Islam. Shahidul Islam, no?
Hakibul Malam. Hakibul is the convict revisionist. Sohidul is the brother of the revisionist.
Okay. You're saying that you did not understand the language.
Yes, madam.
Yes, what do you say?
Your Ladyship, the main ground is that the plea of guilt was not voluntary.
Not properly
Yes, not
interpreted,
proper. Yes, that is the plea. Now, Your Ladyship, we cannot go beyond the records, and Ladyship may kindly consider perusing the record, whether it has been properly explained to
There is
the
nothing, there is nothing.
Your Ladyship. Otherwise, even if we go by
It
the
just
impugn
says-
order,
It just says, heard granted counsel on the guilty plea and the same found to be voluntary, hence accepted. That whatever is stated in the order, only that much.
Yes, yes.
In the order sheet also, there's nothing.
yes, that is there. That is reflected. That the plea of guilt is voluntary.
I think it's better to remand it back.
Ladyship, that I leave it to your.
Because whatever it is, if it was just a case of fine, that is okay, but personal liberty is involved and he has been given 6 months, isn't it? 6 months imprisonment. And for that, I think trial is necessary, in all fairness, no? We'll remand it back, okay? For fresh trial.
De novo trial.
A de novo trial.
Yes.
Sentence would be completed next week, Monday, madam.
Oh.
Yes, so ground infractions.
Then,
only 6 months was given.
then it will not serve any purpose.
Yes. On the grounds that he was not properly explained to him, I pray that he may be acquitted, my lord.
Wait. Sentence will be completed when?
20 next week, Monday. Judgment was on.
No, but then he's on bail, isn't it?
Yes, he's on bail, yes.
He's been on bail all
Yes.
along.
Yes, yes.
Then that will not count.
Yes.
Okay, third unit counsel, Mr. Medovero, as well as Miss S. Mariha, PP, then not reserve for chamber or disperse in the chamber.
Obliged.
This is also sent to the chamber. That's all.
Advance the holding ke mati dili de ani de. Ayo class. Oh sama sa. Khatam hole tan ani de mati dili de.